Good morning. Good morning. Welcome, welcome. My name is Nate Kazmarek, and it's my pleasure to serve as Vice President and Director of the Practice Groups for the Society. Welcome to Day 3 of the 2023 NLC. I'm a little biased, but I think we've had an excellent 2 days, and as you've come to expect over the years, we plan to keep the foot on the gas and finish off the conference with another great day of debate and discussion. A reminder to those of you seeking CLE, please scan your QR code on the back of your programs to sign in and sign out today. As we start today, I'd be remiss if I didn't mention to you that my favorite lawyer is also my favorite veteran. My father, Bob Kazmarek, served honorably in the Vietnam War, and I hope he is watching on the live stream today. And I want to say to him and all the veterans joining us virtually, and those of you here in the audience here at the Mayflower, that we revere your service. We owe you a deep debt of gratitude, and I'd ask that we'd please join me in thanking all of them for their brave service. Before I turn to our great showcase panel, I wanted to flag for you a new project from the practice groups, which we are really proud of and think you will enjoy. 3 weeks ago, we launched a new platform showcasing important legal and policy debates on our website. We've called this new webpage Briefcase, and is designed to host in one place a debate that mimics the litigation process with short written briefs, video recordings of oral argument, amicus briefs, and a poll for the public to choose the winner. On page 34 of your program, you can scan the QR code there, which will take you directly to the first debate, which asks the important administrative law question, should the Chevron doctrine stand? There you will see Practice Group Executive Committee member Mark Chenoweth from NCLA debate Professor Ron Levin of Washington University and St. Louis School of Law. Polls opened on Thursday with the start of the convention, so please check out the excellent debate and vote for who you think made the better case. Our hope is that many important Federalist Society debates will be presented via Briefcase in the months and years to come. Turning to our showcase, it's a delight to welcome to the stage this all-star panel. We are fortunate once more to have the expert assistance of Judge Katsas to help us navigate this discussion. Judge Katsas was appointed to the United States Court of Appeals for the District of Columbia Circuit in 2017. Prior to that, he served as Deputy Assistant to the President and Deputy Counsel to the President. He previously served in many senior positions at DOJ. He clerked for Judge Edward Becker of the Third Circuit, then Judge Clarence Thomas on the DC Circuit, and to Justice Thomas on the Supreme Court. Judge Katsas is a graduate of Princeton University and Harvard Law School. He is so generous to the society, and we are always fortunate to have the benefit of his insights and expertise. Please join me in welcoming Judge Katsas and this great panel.
Thank you, Nate, and thanks to all of you for being here bright and early on a Saturday morning. Our topic is originalism on the ground. This is largely a continuation of the first panel Thursday morning. We are not primarily focused on high-level theory. We're focused on some practical issues when you try to operationalize originalism. One can do that as an academic, writing originalist law review articles. One can do that as an advocate, writing originalist briefs. One can, of course, do that as a judge, either writing originalist opinions or taking a step back, deciding whether or not to try. We have on our panel 2 very distinguished judges and 2 very distinguished academics, and collectively the panel also has very significant experience as advocates. So we've got all the relevant perspectives covered, So let me just introduce our panelists and get things going. John Harrison is the James Madison Distinguished Professor of Law at the University of Virginia School of Law, where he teaches constitutional history, federal courts, and civil procedure. He graduated from Yale Law School, clerked for Judge Bork on the D.C. Circuit, and has served as counselor on international law for the State Department and as a Deputy Assistant Attorney General in the Office of Legal Counsel. Andy Oldham is a judge on the Fifth Circuit. He graduated from Harvard Law School, clerked for Judge Dave Santel on the D.C. Circuit and for Justice Alito on the Supreme Court. And he served as an attorney advisor in OLC, as Deputy Solicitor General for the state of Texas, and as General Counsel to Governor Greg Abbott. Jed Shugerman is a law professor and the Joseph Lipsitt Scholar at the BU School of Law, where he teaches constitutional history, Fed courts, and administrative law. He received a PhD and JD from Yale, won the Charles Freed Award of the Harvard FedSoc chapter, and is working on a book questioning historical support for the unitary executive theory of the American presidency. Randy Moss is a judge on the District Court for the District of Columbia. He graduated from Yale Law School, clerked for Judge Pierre Lavelle on the Southern District of New York, and then for Justice Stevens on the Supreme Court. Chaired the Regulatory and Governmental Affairs Department at Wilmer Cutler, and served as the Assistant Attorney General for OLC. John, you're up first.
Thank you. I'm going to act a little bit against type as a law professor. Rather than giving you high-level theory, I'm going to try to make a practical suggestion based on actual facts. Whether a law professor will be able to do that, we will find out. First the actual facts, then the practical suggestion. The actual facts and the practical suggestion are sort of framed by something that happened in this room a few years ago when the Rosencrantz lunch featured Richard Posner talking to Mike McConnell. At one point, Judge Posner was railing on the use of history in law, probably railing on originalism, making the point that the study of history requires an enormous amount of effort. As he said, people devote their lives to this. Mike McConnell said, the same might be said of economics. The room dissolved in laughter then, as it did now, appropriately, but both of them had a point. Posner was making the correct point that there are specialized bodies of knowledge, history and economics, the production of which requires a great deal not only of expertise but of time and effort. Mike McConnell was making the point that that's true, but decision makers, including judges, often have to make decisions about very sophisticated and complicated arguments concerning, for example, history or economics. There must be some way to reconcile that, and that's what I'm going to try to do in the next couple of minutes, is talk about how hard it is. Those are the observations. I have 3 examples of that. And then the actual practical concrete suggestion, as I say, coming from a law professor, it may or may not be actually useful. The observations, the 3 examples, are to make the point that coming to grips with the work, the relevant information, the relevant evidence on lots of questions concerning, I'll say, originalism, basically original understanding of constitutional text, although that's not the only form of originalism, requires an enormous amount of effort. I'm going to give 3 examples of that. One, as you've heard, some people on this panel are involved in the ongoing debate on the unitary executive, in particular president's removal power. The example I want to give starts with the Myers case in the 1920s, decided by the Supreme Court, written by Chief Justice Taft, an opinion that is so long you might call it Taftian. Taftian was a person of substantial size. Myers was argued in the fall of 1924. Chief Justice Taft assigned it to himself, worked on it the rest of the term, worked on it the whole summer, worked on it the next term, worked on it the next summer, had a heart attack in the process, and ended up, after almost 2 years, producing what we now know as the Myers case, which, as I say, is very, very long, was based on an enormous amount of personal original research by the Chief Justice, then lengthy exchanges among the justices, work by the Chief Justice's law clerk. They had only one in those days, who was the late Judge Steve Williams' father, interestingly, the Dickerman Williams. And since then, there has been even more work on the issues that Chief Justice Taft discussed and raised, including recent work by Judge Shugerman. The point I want to make is a decision maker who wants to have an informed view on that doesn't need to spend a lifetime, doesn't need to spend as much time as Taft did, or as much time as professors do, but does need to spend a whole lot of time on that. Getting familiar with the basics about the primary materials, understanding the secondary arguments, understanding what judges and lawyers and scholars have said requires an enormous investment of time. I'm going to say on that particular topic, the unitary executive and presidential removal power, just being in a position to make an informed judgment about it is the concentrated work, I will say, pulling numbers not completely out of the air, the concentrated work of days or weeks, maybe longer. Second example, does the 14th Amendment impose the Bill of Rights on the states? Justice Black did a lot of work on that, wrote a lengthy opinion in Adamson against California in the 1940s, a lengthy historical appendix to Justice Black's opinion, a lengthy response from Justice Frankfurter, and that was the beginning of a debate among judges, academics. A great deal was written about this by academics. In my view, that debate very much continues, and a very important contribution to it that's not, I think, not obviously a contribution to it, was made this year by Judd Campbell, now at Stanford. Again, my point is not you can spend your whole lifetime on that issue, you can, but there is now so much both primary material and commentary that, again, coming to an informed opinion on that requires for a judge, other decision makers, somebody in OLC, for example, requires an enormous investment of time. That one, too, is the concentrated work of days or weeks. Okay, those are two examples involving federal judges. We have federal judges and academics on the panel. My third example involves an academic, and now I'm going to quote Judge Oldham. Oh, no. Sorry about that. Who might think that judges, that academics spend too much time on high-level theory, and said, we need thick original meanings. That is, we need more and more work that shows particular constitutional provisions have objectively determinate meanings based on rigorous analysis and academic debate over relevant sources of original meaning. One response is, and cold fusion and room temperature superconductors would also be nice. Where's my flying car? Well, we're working on it. An example of working on it is, in my view, the most impressive and sophisticated piece of original understanding scholarship ever done, published in 1950 by William Winslow Crosky of the University of Chicago Law School, interestingly, my con law teacher's con law teacher. Crosky wrote 2 volumes during his lifetime. There was a 3rd volume published posthumously called Politics and the Constitution and the History of the United States. The 2 volumes are 1,175 pages long, and there are appendices. So maybe in response to Judge Oldham, what Crosky did was an example of what everybody's grandmother is supposed to have said, be careful what you ask for, you might get it. Crosky was, one, immensely knowledgeable about the original materials, about both the conventional original materials and 18th century law. Crosky was, 2, a rigorous textualist originalist. He was hardcore on the methodological point, Krusky was 3, a genius. He brought all those together and took what are today and what were then extremely heterodox views. Krusky didn't believe in enumerated powers. He didn't believe in judicial review of acts of Congress. He thought Erie was wrong. He thought that the Constitution created a uniform federal body of common law that the Supreme Court of the United States was supposed to administer. Like I said, Krusky was a genius. I didn't say I agreed with him. Coming to grips with Krusky, his work, and the commentary on it, once again on any one of those issues, concentrated work of days or weeks, coming to grips with everything Krusky said, because it's a system that works together, that's the concentrated work of weeks or months. Okay, well, socialism is said to be a bad idea because it takes too many evenings. Originalism takes a certain amount of time. That's the observation, as I say, two justices and an academic. The concrete, useful proposal directed to lawyers, academics writing as amici, as they sometimes do, and judges, including, I think, sometimes, especially judges not on the Supreme Court of the United States, is whenever you are talking about what conclusions you've reached about one of these topics that may require an enormous amount of time, try to understand and try to figure out which are the really hard parts, which are the questions that are the closest and that require the most attention. That, if you're an advocate or a judge, that can involve saying, this is the weakest part of my argument. Well, for your audience to know what's the weakest part of the argument, what's the hardest question, can be very important. I'll just give one example having to do with the original meaning, having to do with the unitary executive, which is one of the things Taft talked about at great length, the debates in Congress in 1789 about removal power. I think that it's really important. I am perhaps the rare Unitarian who's not a removalist. I think it's very important to understand those debates in light of the context which had to do with Senate involvement in removal. That's a view of mine on the substance. My sort of meta view that's relevant here is to make the point that what's sometimes called contextual enrichment of people's statements, additional information about what people said in their context, every good lawyer knows you can't understand something outside of its context, requires not only additional information, but very fine judgments. Because if you say, in context, that doesn't mean what you think it means without looking at the context, you are saying, that doesn't mean what you think it means. That doesn't mean what maybe it's literal, what the literal message somebody was conveying was. That kind of very common, very important question requires fine judgment. Often, that's an important pressure point in an originalist type argument. That's a point on which a reasonable person could go either way. It calls for judgment. And people who are making those arguments, I think, should be more candid when they come to something. This is the hard part. This is where judgment has to be exercised. Maybe something else is easy, but this is not. Again, I think that's something that a lot of people, including academics, don't do nearly as much as they should. Be prepared to say, this is where my argument is weakest, this is where you need to focus to economize on time because doing this requires so much time. That's what the observations are about. I will conclude by saying that this panel consists of federal judges and academics. All of us have one form or other of life tenure. One of the things we should be able to do with life tenure is be honest about the parts we're not so sure about. Justice Brandeis is supposed to have said that the practice of judges is to decide 51% and then write 100%. My concrete practical suggestion to everybody is when you've decided 51%, say you've decided 51%. That's how originalism on the ground should work, because that's how law on the ground should work.
Andy.
Well, thank you very much. It's always a joy to be here, and I'll sort of pick up where John left off with a point of agreement. and that is about epistemic humility. I agree 100% that one of the trickiest parts certainly about being a judge, I'm sure it's true about being an academic as well, is that, we're trying, and it's also true about lawyers, I suppose, which is that you're trying to write something that is clear, that is concise, and that is persuasive, and that is often in tension with the idea of recognizing the limits of an argument. At the end of the day, judges have to write opinions that explain judgments. You have to explain to one side why they're winning or losing, and if you get down to the end and you say you're losing, but I'm not really sure why, that is not a particularly persuasive opinion. But I agree with John 100% that it is really, really important to have epistemic humility when it comes to originalism. As I was listening to his remarks, it was evocative to me of that passage from Plato's Apology, which I'm sure everyone's read, about the trial of Socrates, where Socrates goes off to talk to the purportedly wise man, and he gets into a dialogue with him, and he's trying to sort of plumb the depths of this other man's knowledge or wisdom. And Socrates realizes relatively quickly that the man doesn't know very much about anything. And so as he's wandering away, Socrates thinks to himself, I'm better off than he is, for he knows nothing and thinks he knows, whereas I neither know nor think I know. And that is the sort of, I think, so too with originalism, in the sense that we really never know. One of the trickiest parts of originalism is something that my friend Steve Sachs wrote about in the Harvard Law Review last year, which is that we don't know what we don't know, right? And it's even worse, in my view, in some ways, in originalist inquiries, because we don't even really know where to start, right? Or where to end, for that matter. It's not like there's some compendium of originalist instruction that says, well, you start with source A, and after source A, you go to source B, and then you go to source C, and you can stop when you get to source Z. That's not ever written down anywhere. And so it sometimes seems, when we're searching for originalist meaning, and this is true, I think, in the academy as much as it is in a case, we often start at some place that might appear random. It's difficult to explain to some external observer, why did you start with the English Bill of Rights, or why did you start at the founding, or why did you start at Magna Carta? It's not exactly clear why you start in a particular place. It's not clear why you then trace that to another event, and then it's not clear why you stop in your search for, as John said, I wrote a response to Steve's piece in a plea for thick original meaning. How do you determine when it's sufficiently thick that you can then explain to the party A that they're going to win, or party B that they're going to lose? It often has seemed to me, in trying to deal with some of these issues, both in thinking about academic papers, but also in terms of thinking about original meaning in the context of cases and controversies, it has struck me that it seems a little bit like a hound searching a field for truffles, right? There's no particular place where you stop the truck and let the dog out to go looking. There's no particular rhyme or reason about how the dog is sort of searching through the field, sniffing and finding any particular thing. And once the dog finds something, you don't really know if it's actually a truffle, or it's some other kind of mushroom, or it's a rock. And so it seems like it's very difficult in any particular set of circumstances to understand exactly how one is supposed to search for that original meaning. And so that has led to some criticisms, which I think are important for originalists to confront, which is, should we even try? Is the game even worth the candle, or is the hunt even worth the beagle? In my view, we absolutely should try. And I'm a very proud originalist, and I do think that the hunt is worthy of the effort. But I think that we should be very honest, and I agree, again, wholeheartedly with John on this, about the difficulty of the project, the reality of time constraints, and really resource constraints more generally. And as a consequence, I think when we make an originalist claim, it should be the smallest, most modest one that we feel a degree of confidence in making, precisely because we do not know what we don't know. We do not know that the next article by Professor Harrison or Professor Shugerman is going to say, well, the original public meaning of constitutional provision, whatever, 14th Amendment, turns out it's not X, or it's X prime, or it's Y. And you never know what is you have not read, and as a consequence of that, you should be quite careful, I think, in the way that one goes about making originalist claims. And that leads to my second point, which is about originalism and precedent. One of the things I've been most, I don't know if surprised is the right word, but one of the things I found most remarkable in my 5 or so years in my current job is the number of constitutional cases that we see where there is not a clear precedent totally on point that just dictates the answer. You can't just say CAVB, we're done. And so for originalists, that means that we then need to conduct some sort of originalist inquiry to try to figure out what the correct answer is. And when you do that, it's not immediately obvious where the precedent, where the sort of the power of precedent should start and stop versus the power of history and tradition should start and stop. Obviously, if the Supreme Court has said it, then for the inferior court judges, that's as good as scripture, and we can move on. But my court has a very big docket. We have a lot of precedent. There's a lot of it that goes back a long time, and it's not immediately clear how one reconciles a case that may not be quite on point, but may be interesting or powerfully persuasive somewhere in that spectrum, versus a history and tradition that has been developed by scholars and doing the hard work that Professor Harrison was talking about. So if you come across a source, you come across a scholar, you come across a PhD who has written a powerful exegesis on a particular provision, how does that then interact with another Fifth Circuit precedent or DC Circuit precedent that may be either not quite on point, but perhaps close enough? And I think that feeds back to the first point, which is that when you're thinking about establishing those precedents, and this is particularly a plea to the judges, you should be a little bit careful, right, about how much you actually feel confident in dictating, for fear that you end up with egg on your face the next time Professor Harrison writes an article about it and you realize that, in fact, you've missed the boat entirely. And then the last point I'd like to make, which is a little bit about the bench-academy divide. And as Professor Harrison had mentioned, this is one of my, I don't know if frustration is the right word, perhaps it's just a concern. But one of the criticisms of originalist judges, which I think is understandable, is this concern about, it's true about lawyers too, I suppose, law office history, or as I think Justice Kagan has referred to it, law chambers history. And the idea is that, well, maybe you don't need a PhD in history to study a particular constitutional provision and come up with its original public meaning, but you do at least need to have some dedicated research agenda, such that it's outside of a particular case in controversy, that it doesn't have a litigation focus, so it has a broader horizon, it has a better ability to sort of consider holistically a particular provision of history, or a particular period of history and how it interacts with a particular constitutional provision. And the idea being that we really don't want either associates in law firms or law clerks in judicial chambers working on these things and trying to answer these big monumental constitutional questions in the context of particular cases, both because of sort of a competency concern, also because of a time concern, also the fact that cases and controversies may not, in any particular one, may not be the proper way or the lens through which to view these questions. Okay, well, I understand that concern. I've heard it powerfully made in the past, and if we just take it as true for a moment, then I guess the one question is, where do we go to find, if we don't like that, what is the sort of alternative? And so, Professor Harrison gave one good example. There's obviously lots of really great examples of people who have dedicated years, decades, entire lifetimes to studying particular provisions of the Constitution. There are entire theories of, the original public meaning of this or that provision, the Fourth Amendment or Fifth Amendment. But these things are constantly evolving, right? We're constantly finding new theories of originalism. Those theories of originalism are constantly interacting with historical materials in new and different ways. And one of the concerns that I have often had is that if you just, I was, in the run-up to this conference, went on to the home pages of, 3 or 4 law reviews that everyone I'm sure in the room has heard of. And if you just look at the kind of stuff that's being published on a day-to-day basis or month-to-month basis or article basis, there's a lot of, law in education or law in this or that policy or law in this and that social, particular salient political event. And there's not a ton of, here is a dedicated, staked out position on the original public meaning of how the First Amendment applies to prior restraints, or how the First Amendment applies to the establishment of religion, or how these sort of big issues that interact in the cases that federal courts are asked to decide. And I'm not in any way suggesting, I don't want to be confused on this, that somehow the academy exists to make judges' jobs easier, or that that lawyers should be, that academics should be particularly concerned with what judges are doing necessarily. I mean, I think there's a huge role to be had in the academy for just the freedom of thought and the ability to study things that are interesting and to write those papers. But the thing that I think is particularly interesting is that when there are circumstances where the academy and the bench do have to sort of interact with one another, it does happen where a judge will say, well, I think the original public meaning of this is X, and then there's a cacophony of criticism from people who are historians or academics who say, you know, what a buffoon, right? To which one answer from the judge might be, well, gosh, I sure wish I'd heard about that before I had to decide the case. And so I wanted to give sort of one example of what I mean by this. If we could put up the slides, I'll show you. This is a case from my court. I had nothing to do with this case. This is what a case involving a huge constitutional issue sometimes looks like in the Fifth Circuit. So this is a case everyone's heard of. This is Rahimi. So this is a post-Bruin case involving a Second Amendment challenge to a provision in Title 18 and the Gun Control Act of 1968. So this is what the briefing looks like originally, right? So there is a briefing notice, there is one brief and a response brief, and briefing is complete. Okay, so that's like the entirety of what is given to a panel of my colleagues to decide this question. Now, admittedly, this is before Bruin, okay? So that's Rahimi. So this is what the United States government has to say about the constitutionality of this provision in 922G, right? This is in that one brief that the government files, admittedly before Bruin, okay? So after Bruin, the panel issues this directive and says, hey, can we get some supplemental briefs because we're really concerned about whatever, you know, how does Bruin apply to this question? And this is what my colleagues got, right? Appellant supplemental brief, appellee's supplemental brief, and a reply brief. So we've got at least 3 more briefs, so everything's working out great, right? Well, look at what it looks like. This is just at the cert stage of the Supreme Court of the United States, right? This is just the amicus briefs in support of the petitioner, right? Here's the merits, right? Page 1, page 2, right? Page 3. I know. And that's just the one side, right? Let's look at the other side, right? This is now in favor of the respondents, right? 1, 2. And so we could go on all day to show it to you. And I don't really have a firm view on necessarily what the implications of it are. I just think that it's a remarkable challenge to originalism in practice, the topic of our panel. When you look at the way these things get actually litigated, there are a lot of people who have a lot of stuff to say when the Supreme Court grants it. And this goes back to something I think to end on a point of agreement that I have with Professor Harrison. It takes a lot of time. I don't think in any way that, you know, people who have PhDs in history are necessarily monitoring the Fifth Circuit's docket or any other Court of Appeals docket for every one of these cases. But nonetheless, inferior court judges across the United States are being asked to make decisions in these big constitutional questions and having to look somewhere to find the answers. If it's not going to be on the front page of the Stanford Law Review or the Yale Law Review or whatever, and it's not going to be in the briefing, and we don't want them to be doing law office history or whatever, then it's not immediately obvious. It's a lot of no's. It's not exactly obvious to me what is the yes. So with that, I'll turn it over. Thank you.
Jed.
Great. Well, it's such an honor to be here. This is actually my first Federalist Society National Lawyers Convention. But over the course of the year, this is going to be my 5th one of 5 of my Federalist Society or Federalist Society adjacent events. Elena Kagan said way before she was on the Supreme Court, she said at a Federalist Society event, "You are not my people." Now, I will say I've never voted for a Republican in my life. As far as I know, and yet, especially after last night, I think you are my people. I thought Barry Weiss was extraordinary, and I thought your support for what she had to say was also appreciated, and she speaks the truth, I think. But to the point that I want to address here is that, you know, it was before October 7th that I was looking around and looking for more, looking for a respect for intellectual diversity and debate. I mean, that's I did win a Federalist Society prize as someone on the left for bringing intellectual diversity and debate to a classroom where I gave voice to conservative and libertarian students. So I think that's part of the background here. But over time, you know, it's also that I am an originalist. Now, at some point I described myself as a progressive originalist. I no longer use that phrase. I think it's just an originalist and not in terms of I have a lot of respect for what Elizabeth Wydra is doing at the Constitutional Accountability Center, but one of her arguments was, to the left, there's a lot of good results. I am not a strategic originalist. I am just an originalist, full stop. And I do remember a point, but I will also say I'm an originalist in theory, and one reason why I'm on this panel is that I have some questions about originalism in practice that we're all addressing. It is enormously complicated, and I've also learned from experience of my own mistakes, which I'll talk about. I've written or co-written 5 amicus briefs for the Supreme Court and 6 emoluments amicus briefs. Somehow never got to the Supreme Court, but I have some observations and some of my own learning from that experience. But what I will say about originalism, a student asked a question: what should those here say to students who challenge them about, well, originalism is immoral or it's the dead hand? And I think the answer, the basic answer is, that's what law is. It is text and context. Now, I would add that my view of originalism is it's a lexical ordering. It means that there aren't other sources that are helpful, but my view is that text and context are the first order lexical starting point, and only when that evidence is unclear do you go to other sources of law like precedent. What I will talk a little bit about, and I'm picking up on the panel, the terrific panel from yesterday on stare decisis, is I think there needs to be a more robust conversation about burdens of proof and who bears the burden of proof. And I'll talk a little bit about that, given that there are different norms about the burden of proof from a legal system where the plaintiff bears the burden of proof versus if originalism is a historical project. Historians have a different ordering of who has the burden of proof. It's those who make a positive historical claim. X meant Y, you bear the burden of proof. And that works out differently in different kinds of cases with originalism. And if it's about originalism and the Constitution, it also has to be reflective of Article 5 and supermajorities. So what kind of consensus do you need? I think that burden is relatively high. So my view of originalism is there's a lot of space after text and context to get to other sources of meaning, because that burden of proof to establish what the Constitution meant for a broad consensus of society has to be a high burden of proof, generally, if you're making a claim. And the third thing I'm just picking up on this quick question of burden of proof, there's also a question about judicial role, about whether the judge is asked to do something that is activist in terms of overturning a precedent or overturning a federal or a state statute. And that, in the same case, those things can conflict, but I think it's important to think about that as well. So I'd like to see if we have a conversation about that, given that we have this terrific panel with judges who have a harder job than we do in having to have a much broader docket and have limits on time, as Professor Harrison and the Honorable Judge Oldham have both commented on. So let me say a couple of words about my experience in writing amicus briefs engaged with the court. So one is, some of you may have been introduced to me on the pages of the New York Times apologizing for a mistake I made in one of the emoluments briefs. And this is the fog of litigation. And one of the challenges, and it was in a district court, but picking up on Judge Oldham's point, it was good that this was a mistake in a district court brief that we could then air out and not make that mistake again. But it was an apology to Seth Barrett Tillman and to Josh Blackman about a mistake that I was not the most prominent historian on this brief, but it was a mistake that I played a significant role in making about a Hamilton document. So without going into the details there, I think this is my own learning about what we call here epistemic humility or interpretive humility. I recommend a piece by Heidi Kittrosser called Interpretive Humility that I think connects with what we're saying about burdens of proof. But the other observation is that this was a mistake related to trying to figure out whether a document in the National Archives with what appeared to be Alexander Hamilton's initials was in fact his initials or not. I don't think that's covered in law in like 1L or 2L or 3L. And one mistake we made was over-relying on something that a couple of us had learned in grad school about the signing conventions
of the way that documents were archived in the 18th century. And we had assumptions that what we learned in our PhD program were, we relied on those conventions. Turns out those conventions were wrong. But thankfully, there was a debate, and I think it's important to acknowledge when one has made a mistake. So again, if Josh or Seth are out there anywhere, again, my apologies. But then one other point is about this work. This is not an emoluments brief, but I did some work on the unitary executive theory on the word vesting. And when I placed that article, I had a conversation with Larry Solomon. I'm not sure if Larry is here. But Larry gave me some very constructive feedback. That what I had done is I had looked at something like 100 different dictionaries from the 1600s, even into the 19th century, about the word vesting, that showed that there are assumptions about the word vesting throughout the Constitution that do not mean what we think they mean. I think I'm paraphrasing Princess Bride here. I hope some people got that, right? Inconceivable. So the idea about, there's an assumption that, and this is something that we call semantic drift. Julian Mortensen has used this very effectively, that we have presentist or modern assumptions about the words we use, and we all, in our common law classes, read Chief Justice Marshall's opinions from Fletcher versus Peck, or et cetera, the Dartmouth case, that talk about vested rights. And we assume that that word vested means legislatively indefeasible. Well, it turns out that in the dictionaries and usage, that vesting only gained this meaning. It shifted, a semantic meaning shift in the 19th century given written constitutions. So that was the main find. What was one of my findings? And Larry Solomon said, well, you're over-relying on dictionaries. And he's right, I was over-relying on dictionaries. He said, you have to look at usage. And so then, taking that seriously, I went with research assistants, went through the databases to look for every use of the word vesting by the founders from in one of the databases that's at the University of Virginia from 1776 to 1789. And I found something that, frankly, I was not looking for, and it surprised me, but it became clear that there were different flavors of vesting. So there were references to something being fully vested, and Washington would often refer, or if something was delegated to General Washington, it might be fully vested in Washington or an officer, or it might be fully vested from Washington to another officer in a military context. Tax policy. Tax rules often had this usage, and there were also references to things being partly vested or temporarily vested. And it became clear that vesting didn't have its own clear meaning, but there were flavors of vesting, including all vested, all power being vested, plenipotentiary. And it dawned on me, well, wait a second, there is a place in the Constitution that uses, tell me if stop me if you've heard, if you think you can recognize this phrase, all legislative power shall be vested in a Congress of the United States. And it struck me without looking for it and without, frankly, sympathizing with this view as on the left, but realizing as a commitment to originalism, I added to the article after it was placed, frankly, in the Stanford Law Review. I thought, I want to get this right. And I said, there is an argument here from this evidence in favor of the non-delegation doctrine. That when the framers were writing the Article 1 and Article 2, this cuts against the unitary executive theory because the word all is not used there. Article 2 says the executive power shall be vested in a president, but Article 1 says all legislative power, and I don't think it's just the herein granted that limits that. I think there is a context to that in terms of the realities of 18th century governance and republicanism. It was very important to have all power vested in your Democratic and Republican body, but realistically in the 18th century, there was too much decentralization and no cell phones, no airplanes. Executive power needed to be more decentralized. So in pursuing a unitary executive question, I stumbled on on evidence that supports the non-delegation doctrine, but I do ask a question to those who've been filing briefs. I'm just noting that no one has ever cited my article for any non-delegation argument in an amicus brief. And I think that's reflective of our silos. And one reason why I'm here is not just that increasingly I think I want to talk to people who are serious about the rule of law, having filed, right? Side note, I filed an amicus brief in Biden versus Nebraska, and I did not file it on behalf of the Biden administration. But I think it's important for these conversations and I also want to emphasize that in the legal academy, there are more and more JD PhD historians who understand and take seriously the idea of original public meaning. And so I'm here to learn from you, but you're welcome to cite my work if you'd like to. On another note about this research, I take what John Harrison is saying very seriously about the complexity of this material, and there's also a challenge when publishing law review articles about what the conventions are. And so one experience I had in publishing Indecisions of 1789 about the problems of with the unitary executive theory's interpretation of the First Congress, I submitted it as a 50-page article. It then it grew to 114 pages. I do not think the editors, let me just appreciate all the extra work they did there. And at the same time, I couldn't give all the block quotes from speeches. So they asked me to publish separately a 60-page document in SSRN, and the way that I tried to resolve this was using an SSRN document that was cited that they didn't publish, but that I could go and give several paragraphs from the original source and let readers decide for themselves. So I just want to suggest this is another way to engage in originalism. It's hard for judges and clerks to get the full sources. Briefs also have very limited page numbers and word counts. So one thing I've learned is how to use SSRN to then give those who want to dig into the materials without having to figure out if it's been uploaded to a database you can search for, give them the full quotes. What I want to end on here is just saying that one reason why I'm here is that I think it's important to recognize that originalism needs, as the co-panelists have mentioned, needs epistemic humility. And I think one observation I want to make is that it's also true of originalism now that there is such a big supermajority on the Supreme Court to sympathize with certain outcomes without necessarily having all of the requisite experience and expertise to deal with these historical materials. I think there is a risk, and I say this as someone who cares about originalism, is to save originalism from itself. I think there are some overreaches that are happening. I did post yesterday on SSRN a document that gives a little bit more background to this. I'm writing a couple of essays about some of these concerns. In one essay I've titled, "Heads I Win, Tails You Lose Originalism." And just to summarize some of these concerns about the way that history gets used, sometimes post-ratification evidence is relevant, except when it's not, right? Sometimes Marbury versus Madison is relevant, except when it's dicta, right? And so state constitutions are evidence about executive power, except when they're anti-models on executive power. British Crown is relevant for the unitary executive theory, but the English Parliament is not. I go and I explain how these different brief writers have played a shell game with which material is relevant. And in the Lion's Den, I will also say, Steve Calabresi filed an amicus brief where in one page he says that English precedent is of doubtful relevance because of the differences between the separation of powers. And then a few pages later, he goes on to cite British colonial administration as a positive model for executive power. I'd just like to say this is an example of heads I win, tails you lose, right? Colonial British administration is mostly an anti-model for why we needed a written constitution in the state constitutions in the 1770s and the US Constitution. It's the way we understand the Bill of Rights. Colonial British administration is usually the anti-model for the context of the Constitution, except in Steve Calabresi's brief, where suddenly it is the model for executive power. I think one lesson here is we need to have both historians' norms as well as lawyerly norms about trying to have some methodological consistency about what material is relevant and try and theorize that methodologically so that we're consistent and not just trying to achieve ideological results.
Randy.
All right, well, thank you. And let me start by applauding Professor Shugerman because I think all of us need to keep in mind that what is ultimately most valuable is the rule of law and the truth. And I think all of us, whether we're judges or academics in what we're doing, need to hold those values most highly. And wherever the best analysis of the law and history takes us, that's where we should go with it. So I applaud those sentiments from everyone here on the panel today. With respect, with respect to history, I'll go back to Professor Harrison's reference to Judge Posner. And the truth of the matter is that very few, if any, federal judges have PhDs in history. But it is also the truth that we can't ignore history, and that we cannot decide cases in historical vacuums, and we need to understand the context in order to do our best to get the cases and the decisions right. But I think at the same time, Judge Posner's observation is valuable in that we should do so with humility, caution, care, and also thinking about the different contexts in which this comes up. And I want to just touch on some of the challenges as judges that we face in using history. And the first challenge, which has been touched on today, Professor Shugerman talked about this. He's, I think, posted for the CLE a brief that he wrote in the Jarkissi case. But our understanding of history is not static. History is static. The facts that from the past are what they are. But our understanding of those facts are not static. And when we're going back over a period of hundreds of years, sometimes going back to the British common law, I think we do have to do that with an understanding that what we know today may change with time. And that raises a number of difficult questions for judges. What do you do when the understanding improves over time? What do you do when, as a judge, you make a mistake? Professor Shugerman can publish an apology and say, I made a mistake. As judges, when something becomes enshrined in the law based on a historical error, what do you do about that? I think we should think about what rules actually should apply with respect to the overruling of precedent when it turns out that precedent was based on a historical mistake. There's a jurisprudence on how you think about and the rules relating to when to overrule precedent, but I'm not aware of anything that actually struggles with that question and thinks about how do you think about overruling precedent when it's based on a historical error, and then how confident are you that it is an error when when you reach that point. The second point is to think about how do you go about historical fact-finding. When I told my son, who was a third-year law student, that I was going to do this panel, he said, "Dad, stay in your lane." And what I think he meant by that was you're going to be on a panel with some distinguished scholars who spend all of their time thinking about these questions. You've got another job that you spend most of your time thinking about. And so don't go on a panel like this and start opining on theories of originalism and interpretation when you're dealing with people who think about this day in and day out for years every day. And the same thing goes for how you think about history. And as judges, how we think about applying history. It's not something that we're doing on the ordinary day, but we have to make those judgments. And how do we go about doing it? One of the oddities about this is ordinarily findings of fact are primarily the province of the district courts. And in this context, it's almost flipped. And as Judge Oldham made clear in his slides, a lot of times, I mean, if you looked at the district court, the docket would have no amicus filings probably at all.
And it gets reversed, and it's only by the time these cases get to the Supreme Court that you see stacks and stacks of amicus briefs with historians presenting that. Now, not every historical fact is the same. And there's not a lot of uncertainty, although there may be some uncertainty actually involved in picking up a dictionary and reading a dictionary. And I would have thought actually before I sat down here today, say, well, you know, you can pick up a dictionary from 1789, see what it says, and that's pretty certain. But it turns out that maybe isn't so certain. But there are different types of uncertainty and historic doubt that can arise. In some cases, it's less difficult. In other cases, it's more difficult. And in some cases, issues are hotly contested. And in other cases, they're less hotly contested. Again, I could be wrong about this, but my impression is, for example, in the Confrontation Clause jurisprudence, in the history of the Confrontation Clause and going back to the trial of Sir Walter Raleigh, that in Crawford, that was not hotly contested, that history. It may have been contested what the implications were of that history. But other times, I think the history is going to be contested. What do you do with competing amicus briefs? You have the one stack on one side, another side, and they're telling you different things about history. And as an appellate judge or as a Supreme Court justice, how do you go about resolving that? I mean, I can tell you at the district court, if I have a factual dispute, I want to bring those witnesses in. I want to have them on the stand, and I want to ask even experts. I want to ask them my own questions, and I'm not content. And I tell you, very rarely am I content just picking up an expert report and reading it and saying, oh, okay, or particularly when they're competing ones and knowing what I think the right answer is. I want to be able to ask them questions. Supreme Court justices, they can ask the advocates questions, but they don't have those historians in front of them. And again, I'm not suggesting that every historical question is like this, but could you imagine a case that turned on an important question of science in which, not litigated in the district court, litigated in passing in the courts of appeals, and it gets to the Supreme Court, and there are stacks of amicus briefs by scholars of organic chemistry on one side and scholars of organic chemistry on the other side. The Supreme Court would remand that and say, you got to go back down and sort that out. We're not going to decide some question of organic chemistry based on the amicus briefs. And I'm not suggesting that all history or even most of it is like that, but I really raised that point to show the challenge of deciding difficult questions of historical fact in a world in which there oftentimes is not tremendous percolation, even in the courts of appeals before it reaches the Supreme Court. And it gets teed up for the first time in the Supreme Court with amicus briefs. And although I would like to think and hope that the authors of each of those amicus briefs are approaching it with a scholar's independence and objectivity, I think in truth, at least many of those amicus briefs are written by people who, for instrumental purposes, who have a view in where they want to come out on an issue, and which raises the question of how much confidence should the judge or the justice place in those amicus briefs? Do they have to, again, go read all the sources themselves, original sources? Do they need to go to the archives at UVA and go through them? The third point is, in light of that uncertainty, what do we do? And there are different types of uncertainty, and I think this can inform the relevant jurisprudence and perhaps these questions of the relevant burdens of proof or how judges think about it. There may be uncertainty simply because a question is an obscure one and it just hasn't been studied much in academia. Again, you know, in some worlds, you know, the Supreme Court or the Courts of Appeals might allow the question to percolate in the lower courts first before they decide the issue, or would want some further development. But what do you do when there's just not that much out there? And even by the time it gets to the Supreme Court, it may be that scholars run out then and start doing the research at that point in time, but that may be 6 months or a year of research versus a decade or decades of research. There's other types of uncertainty. There may be questions where the framers themselves weren't in agreement. It may be circumstances where they were intentionally vague because they weren't in agreement about an issue. It may be that there are issues that just never occurred to them. It may be that there is no historical analog to go to, where the historical analogs are just not terribly helpful. And so I think thinking about the type of uncertainty can inform how you go about approaching it. And the fourth point is, and I think this touches on my opening comment about the need to be objective and open-minded and take things where they, to reach results that really represent the rule of law. And that is, I think that there is a risk when you're relying on history that you're going to fall into the same trap that people decades ago fell into with respect to legislative history. Judge Harold Leventhal famously observed that legislative history, at least at times, can be like going to a cocktail party and looking across the room for the heads of your friends. And there's, I think, the same risk, at least at times or in some circumstances, with respect to historical evidence. And where there's a large historical record, there's a risk of going out and finding your friends in that historical record, rather than stepping back and approaching it with real objectivity and figuring out which are the most important pieces of the historical record. And I think in that context, we, as judges and as academics, need to think about how to maintain public confidence in the work of the academics, in the judiciary, and make sure that we don't fall into the trap of finding our friends in the historical record. So my bottom line is we need history, we need to understand history, we need to do our best with it to decide cases fairly and correctly, but we also have to do so with caution and need to consider the types of history and the different types of traps that we can fall into and make sure that we avoid those.
I'm going to give the panelists a chance to comment on anything they'd like from the co-panelists, and in order to make sure we have plenty of time for questions, I'll ask you to try to keep it to maybe 2 or 3 minutes. John.
Thanks. I want to, the particular thing, because of course economizing on time is very important, that I'm going to talk about is what Judge Moss was just discussing. It seems to me that it would be a really good idea for courts, with the assistance of lawyers and academics, to develop a way to deal with new historical learning, to develop a way to adjust, when appropriate, their understandings, including of the Constitution itself, based on new knowledge. That would require, I think, some adjustment in the way principles of stare decisis operate. Judgments might be taken, opinions might be taken as standing for propositions with the explicit understanding that the decision was made on the basis of the then available understanding and the then available learning. I mentioned Kroski, I mentioned my con law teacher who was Kroski's student. My con law teacher started off in antitrust. He would later write a book called The Antitrust Paradox. And one of the things that has happened in antitrust law over the decades, in part because of then Professor Bork's work, was that judges came to think that they had a better understanding of the economic principles that are made relevant by the quite abstract concepts built into the antitrust statutes, mainly the Sherman Act. They had, they thought, a means of doing evolution of their doctrine based on better understandings, based on new learning, largely in economics, to get back to Posner and McConnell. That shows that it's possible. And I hope that if concerns about the original understanding, concerns about the original meaning of the Constitution and statutes continue for a substantial period of time, as I say, that judges and lawyers will start to develop techniques to develop and evolve precedent and understand they shouldn't be locked into something they said 40 years ago, now that there's been new learning.
Andy? Andy?
Thanks. I'm going to pick up on one thing that Professor Shugerman said that I agreed with the remarks. But one of the things that you highlighted, which I think is really, important about the heads I win, tails you lose theory of originalism, is one of my principal concerns has been that we don't have a generally accepted sort of order of operations. You know, when it comes to economics, with which I have just enough background to be dangerous, you know, there are certain rules, right? There are certain, it is at the end of the day, some of it anyway, math. And there are a certain generally accepted assumptions about how one goes about, you know, calculating GDP, or, you know, or even in microeconomics, how one goes about, you know, figuring out what the marginal costs and marginal revenues are. There are things that we can at least, if you got a group of 100 economists together, we would agree on how to write the equations. We may disagree about some of the theories, we may disagree about some of the applications, but there's some bedrock sort of conception of how one goes about doing it. But one of the things I think that you've raised that's really important is that when it comes to originalism, why in one case would you start with Eliot's debates? Why in another case would you start with colonial practice? Why in a different, doesn't matter what the state constitutions say? Why does it sometimes that the colonial practice is the anti-rule? And why is it that we're sometimes deviating from English practice? And so, I mean, so part of it is like, how do we know when something is evidence of the absence of constitutional meaning or the anti-constitutional meaning? But some of it also is, it's not completely obvious to me how we even go about figuring out the step A, step B, step C, right? Much less where we stop, right? Like when can we finally be confident and say, okay, well, that's good enough, you know, for this case, and we therefore have reached the 51% confidence interval that Professor Harrison mentioned in his opening, and, you know, judgment for the plaintiff. And I think that's one of the biggest challenges of originalism in practice, is figuring that out and legitimizing so that in a sufficient way so we can explain to a party, you know, this is why we're going to rule this way, is because, you know, we're confident that we started in the right place, we took the right steps, and we ended in the right place, at least as to today.
Great.
Thanks.
Good. I'm happy to pick up right there because I'm actually struggling with this problem. Don't get me wrong, just because I've said, well, sometimes some sources get used, sometimes the British Crown is cited, but sometimes when it's convenient for the argument, but Parliament is dismissed because of the Americans rejected parliamentary supremacy. Sometimes that's true. I mean, sometimes, but you need evidence to explain why it's one versus the other rather than just make those assertions. And frankly, I'm getting feedback about a paper I have posted on the history of venality or freehold offices. There was a robust tradition that went into the 19th century in England where there was the sale of office, and the exchange for the sale of office was then, once you bought an office, some of those offices were family property that would be passed along, and Montesquieu wrote about this in Book 5, Chapter 19 of The Spirit of the Laws. And the pushback has been, well, the sale of office and the ownership of office was part of a monarchic or aristocratic system and not a republican system. And one way I've got to deal with that is to say, well, that's reflective of a lack of consensus about offices because some of those practices continued. But I have to make that argument more clear. I think it was an exposition. I think in my head, I knew that was a distinction. But as I've gotten feedback from moderate, conservative, and liberal scholars who all have different problems with where this research goes, I'm now trying to be more careful about avoiding the heads I win, tails you lose problem. But I also, I appreciated Judge Moss's reference to the going to a cocktail party and finding your friends. I also go to the Originalism conference. I went last year to the San Diego, and one thing, and it was tremendously helpful, and I appreciate the feedback I got, but one thing I heard in the comments when, based upon research was, well, there was a phrase that came up, and someone in the audience said, well, just go into the databases and hit Control F and look for that word. And now, in addition to this essay I've just posted, again, on SSRN, Heads I Win, Tails You Lose Originalism, get it when your SSRN documents are sold, I'm also going to be writing an essay called Control F Originalism, where the risk is that you go to a database and you Control F your friends. Just to be clear, Control F, the F stands for find. I think one last thing I'll say is about epistemic humility and judicial activism versus judicial restraint. I also went to the Boyd and Gray Center in September at Scalia Law School, and Mike Ramsey presented a terrific paper about the major question doctrine. And one observation is that And there's a risk here, but when there is doubt about, let's say, a constitutional doctrine like the non-delegation doctrine, and the backup, and I want to, again, this is breaking from my ideological bedfellows, and so it's just a metaphor, by the way, that I defend the major question doctrine. And one defense of the major question doctrine, Mike Ramsey made this more clear. Scalia said in Mistretta that because the non-delegation doctrine is so hard to administer, and also maybe there's also this epistemic doubt about its scope, the major question doctrine is most justifiable, not in Amy Coney Barrett's terms and her concurrence, Judge Barrett's terms and her concurrence, as textualism. It really is, I think, in Gorsuch's conception, a doctrine of constitutional avoidance of the non-delegation problem. And that is a more restrained way to enforce that constitutional commitment. So I would just endorse the idea that sometimes judges, when the history is unclear about constitutional interpretation, that statutory interpretation and the doctrine of constitutional avoidance is a second best, or maybe a first best.
Randy?
Well, I'll be very brief since I was last in any event, and I'll simply say that it's been a pleasure to be on this panel with all of you, and one of the things that I think is most interesting to me is how much agreement there is among the panelists.
Okay, we have about half an hour, plenty of time for questions. There are 2 mics on the side if people want to start lining up. I'm just going to take the moderator's prerogative and ask the first question or put an idea on the table. Oh my gosh, we have long lines. Very practical. I was struck, John, by your formulation of days or weeks of concentrated effort. So let me kind of think that through as a judge with a docket and a budget. So I have to decide 9 cases a month. Many of them are tremendously complicated ad law cases, and before I can do a deep dive on the law, to borrow a phrase, I have to spend days or weeks of concentrated effort just to figure out how the administrative scheme works, what the agency did, and so on. Those are my numbers. I'm pretty confident Andy probably has 2 or 3 times as many cases as I do, and Randy probably has, a couple hundred at any given amount of time.
At least, yeah.
So days or weeks of concentrated effort to figure out one case, like the numbers just don't add up. So I guess my question for the judges is, how do we make the numbers add up? And for the academics, can you help us out?
Sleep less?
You want to go first?
Yeah, that's all I've got is sleep less.
Yeah, I mean,
I need more sleep than you do, Andy. I know your sleep schedule.
I think part of the answer to that is also sorting through where your time is really most needed.
Right.
We all would like to have more time for all of our cases. But when you have a case that raises a particularly important question and it involves difficult issues, including history, we'll end up spending more time on that. We'll still wish we had even more time to do it, and that's part of the problem here. But I think it is a question of just how you allocate your scarce resources.
Okay, let's go to questions. We'll alternate back and forth, and we'll start over there on the left. Go ahead.
Hello, can you hear me? All right. Having read a number of originalist decisions over the years and a number of non-originalist decisions here and there as well, I find there's usually a section in every originalist decision that goes to heterodox result that has what I call the oh, but don't you worry section of the opinion. For example, well, this isn't an opinion, but before Judge Oldham went on the bench, he wrote this very long and very good law review article basically saying the Sherman Act was unconstitutional. But then in the lower sections of his opinion, he had one of these sections where I call the "oh, don't you worry" clause, where he said, "Oh, but don't you worry, if we get rid of the Sherman Act, there'll be plenty of state antitrust laws that we can just use instead." I'm from Pennsylvania. We don't have an antitrust law, so Or the little section of Heller where it says, oh, but don't you worry, these particular gun laws are fine, or another example. Should we have those sort of sections of opinions if we have originalist opinions that reach that or reach any decision really? And if so, why? If not, why not?
It's always haunting when something you write in law school comes back. I think one answer to that is that, I think really if there's anything that this panel agrees on across the board, it is that modesty is perhaps the principal command. And so I think what might be termed as a don't you worry section could also be phrased as to say, like, listen, maybe I'm wrong about this, or maybe the consequences of this are different than I'm anticipating. But here are some reasons that it might not be as terrible as you might think. And so I think having some degree of caveats is always important, and for any number of reasons, and in particular when it comes to actually judging, because of the fact that you could be wrong. And these cases are important, and the precedents are important, and we have to build into them some ability to recognize the limits of what we're doing.
Yeah, it's hard to answer that question entirely in the abstract because it's gonna vary from case to case and an opinion to opinion. But what I would say is, I do think that judges need to struggle with and consider the consequences of what they're doing. If the law leads them to a result and the consequences are not good, but that's the result, they're stuck with that. But I do think that we do need to think about the consequences. And I also think that it's important to make clear if an opinion has a limited reach, that it has a limited reach, because everyone, there will be folks out there who want to read it as broadly as they can. If in fact the court only intends it to go so far, indicating that can be valuable, particularly with appellate and courts and with the Supreme Court, to make sure that it doesn't invite more trouble perhaps than the authors of the opinion anticipated.
On my right, I can't see too well through the lights, but go ahead.
Good morning. Art McAmer, Coeur d'Alene, Idaho. I am an active litigator and struggle with these issues all the time. And I appreciate the academicians. We got to get the answer right for all time. I think that's kind of in the arguments. The judge's task is we got to get the law right for these set of facts. And so recognizing the limits on time, the limits on brief length, and then the limits of the facts as they're given in the trial court, especially at the appellate level, but also in the trial level. I'm interested in what the panel can tell us about what they see as the effect of the adversarial system on fleshing this stuff out, because you can take an originalist approach, and of course you start with the text, right? And then you jump off into the cliff of historical swamp. And there are different analytical methods you can use depending on which side of the argument you're on. And so what is the effect of the adversarial function in the court system on these arguments?
I can jump in and just say, one part of my experience is learning from, first of all, that the adversarial system is the design of the system, but it should not be part of the approach to the writing of history. And so I from experience, and I appreciate what Professor Harrison is saying too, I try and take this to heart, because just to say to the historians out there that it's important to, and do as I say, not as I do, but to let that adversarial system take the best of it. And I think that's actually been helpful in honing these different arguments. I do want to add something about the role of amicus. I work for free. Every brief I've written, I've never been paid for a brief, but and my co-authors have not been paid either. I think my concern is about Bruin and Rahimi and what Judge Oldham put on the up on the board, is that I would not work for free to do that kind of digging. It's one thing to try and explain what the word emolument meant, or to translate the articles we are already writing into a brief, but in a case-by-case perspective. And I've agreed for free to help the NAACP out with a question in Mississippi about judges and prosecutor elections. But that's based upon my research I've already done. My concern about Bruin, we're talking about the problem of originalism in theory versus originalism in practice. I'm just picking up on what Tara Grove, her excellent observation in yesterday's panel. Bruin is unmanageable for how historians are going to work. And there's an assumption that, just have historians do the research for district courts. I have a hard time imagining how that's workable over the long term.
I think there's a negative effect often from the adversary system because especially lawyers with clients, including who have a client when they're ostensibly filing amicus, think they have to write 100%. And so you get a brief on one side saying, it is obvious that we're right, and a brief on the other side saying, only an idiot could disagree with us. Well, apparently there are a lot of idiots out there. And I would like to ask the judges, when a brief is more persuasive by saying this is a hard question, and then of course explaining why we're right and my client must win, but recognizing that it's a hard question. Because I think counsel have a fear that they should never do that.
I think you're certainly right about that, and that both as a matter of oral advocacy and written advocacy, lawyers who are willing to be candid with courts with respect to areas where they're stronger or weaker tend to be more effective. And I can tell you that judges bristle at statements in briefs that say, there is no doubt whatsoever that no sane person could think otherwise. And you immediately, as a judge, start thinking to yourself, well, what's the argument for the other side then when people do that? So I think it's a matter of advocacy. That's right. The one thing I will say, though, in response to Professor Harrison, though, is in some sense, I think the amicus briefs may be able to strike that balance. One of the things that's a little bit more comfortable for judges, though, about the parties' briefs is that you know where they're coming from. You know what their job is, and you can weigh it in that context. It's not as obvious to the courts with respect to amici, and the advocates have to live by a set of rules that amici don't live by. And if a party is raising an argument on appeal for the first time, they may not get away with that, or they're raising it for the first time in the Supreme Court, whereas amici just do that freely. And so there are some greater constraints which actually give some comfort to judges on the parties.
Next question.
Thank you.
Good morning. Brett Busby, Supreme Court of Texas. Thanks to the panel for the wonderful practical observations on how this work can be done in courts. We also don't get very many amicus briefs, and I wanted to pick up on something that Judge Moss said about it sure would be nice if they came in the trial court and you could question the experts about, well, let me push on this. How does that really work? And I wonder if that's an analogy that maybe helps us think about this, because in scientific expert testimony and other types of expert testimony, it's actually quite disfavored to have litigation-motivated research done where you come up with a conclusion just, not based on any prior scientific or other expert inquiry. And I wonder if the panel has thoughts on, should you give different weights to amicus briefs depending on if the research was done independently before this particular controversy arose, or maybe the amicus brief is at least citing things that were done before versus research that's being done on the fly in the context of a particular case to try to answer a particular question?
I'm happy to jump in. Yes, I think ideally it would be some pre-existing body of law, but we see this all the time in cases too, where, and I appreciated also Judge Moss's observation about this. Expert reports are almost always drafted, right, in the context of a particular set of litigation. And yes, I'm sure it draws on some body. You're qualified as an expert based on the stuff you've done in the past, but at the end of the day, Judge Moss has to rule on a Daubert motion based on an expert report that was drafted in anticipation of litigation or in the crucible of litigation. But at least he gets to cross-examine those witnesses. And one of the things I think is so remarkable about what happens in originalist cases. One of the cases I was thinking about as we're having this dialogue is a couple terms ago, the Torres versus Madrid case, where the question presented is, what is the original public meaning of the Fourth Amendment as applied to seizures, and does an attempted seizure constitute a seizure? And what was amazing about that case is that everyone, but the majority and the dissent both agree about the relevant sources of material. There's none of these complexities about, like, is this all, drafted in anticipation of litigation? Are we looking at the relevant stuff? Both sides say, look, we're looking at the same body of stuff. It's Blackstone, it's, these things from the founding, and both sides agree even as to the relevant precedent, this Countess of Rutland case, and with the touching of the mace in a civil bankruptcy proceeding, like, everyone agrees as to all of that. And then the majority and the dissent both say that the answer is obvious, right? Go ahead. And so I don't know what the right way out of that puzzle is. But I mean, yes, ideally it would all be sorted out ahead of time. But practically, I have a hard time thinking it would be.
It would be great, and I can't think of a way to do this, if there were a legal or historical equivalent of pre-registration in social science. For researchers to say, before they conduct the research, here's the question I'm going to try to answer, and I'm going to publish it however it comes out.
Mm-hmm.
Please.
Harry Lewis from New York. I'm a voracious consumer of history of all kinds, and as many of my friends know, but I'm observing as I read the more contemporary books and articles and things that many of the newer histories are becoming increasingly woke. And obviously in this context, because we're all we're talking about an Enlightenment settlement. This is a brilliant panel, but everyone in the room assumes that Enlightenment principles of argumentation, debate, opposing viewpoints are going to be fairly heard. This is at the foundation of our legal system, but we're starting to get a competing historical and philosophical perspective called, we understand as woke, that really rejects basic Enlightenment principles in reading, understanding, analyzing history. So my question to the panel is this: given this competing, this rising surge of competition, if you will, and I think it's obviously a throwback to a less enlightened time that this is now happening. It's starting to submerge some of the historical organizations. Historians are being silenced now in our society. And Barry Weiss yesterday, noted we're kind of the last bastion, but just a quick question to the panel. Are any of you starting to perceive what I call this sort of debasing of the historical currency in a legal setting? Or do any of you have concerns about that? Do any of you have further thoughts about that?
I'll just quickly say, as I speak to my friends who are in law schools, but my friends who are professors in other areas, the law schools are, after October 7th, and it may not be obvious from the news, but law schools are handling this better, and that's a low bar maybe, but the universities have frankly been a disaster. Law schools have been better. And so I just want, there are explanations maybe because of professionalization, maybe because thankfully some employers had standards about when to rescind offers that had an effect, and sometimes chilling effect is good when it means people need to chill out. So I just want to, that's one observation. The other observation is tenure is an amazing blessing. And thank goodness. And so someone who has, written things recently that get the left as upset with me as some things I've written in the past that get the right upset with me, I still have, I feel like I've got this privilege, and I think many of us use that privilege effectively without feeling like, that there's this blowback. So I just want to say, like, I think the Academy still is thankfully engaged with integrity.
Next question.
Thank you, Your Honor. Cam Atkinson from Connecticut. I had a question about the choice for a litigator deploying originalism. I litigate both First and Second Amendment cases, and one of the challenges I see in choosing to deploy originalist arguments is obviously Bruen recalibrates Second Amendment analysis to an originalist argument, but we're still dealing with the tiers of scrutiny in First Amendment litigation, et cetera. And many of the panels I appear in front of at the Second Circuit, et cetera, we don't know who our panel's going to be until the week of the oral argument. Are there signs lawyers should be looking for in terms of when a court is going to be receptive to an originalist argument, or they're going to follow what I would call the more traditional path of analysis of what can you analyze or analogize to precedent?
Any takers?
Well, the First Amendment is a great example of a place that is thick with precedent and perhaps thin with original meaning, or at least when it comes to things like speech. And I'm as receptive to originalist arguments as anyone I hope you'll find. But at the end of the day, especially when you're coming to an inferior court, there's a lot of precedent, and we're bound by it, and that's the end of it. I think the interesting question is, what do you we have the same practice of we don't announce our panels until the Monday before the arguments. And so, I think there's a huge virtue in that, because you don't know who it is that you're talking to, and therefore you have to make the best arguments you can for your client. And at the end of the day, there are originalists on a wide spectrum of these issues, and I think the more we litigate those, the better off we will be.
Hoping to get to everyone, it's going to be close. We'll go to rapid fire round. I'm just going to ask for our quick questions, please.
Yeah, so pretty good at that. Charles Miller, Institute for Free Speech. So this is our practical panel, right? So we know advocates are going to advocate. We also know that historians aren't typically running in until the end. So my question is this. When there, are there historians out there that are briefing to the Supreme Court, and just sometimes saying the history record is actually inconclusive, and not doing advocacy either way, just saying that, hey, we can't get there yet? And then second, when there are sort of disputed historic facts, should the Supreme Court develop some sort of, fact-finding process with a master commissioner or special whatever to kind of, get to the historic answer?
Well, I'll just answer the second question, which is, I think there are lots of things we can do to try and address some of the issues that have been flagged today. I don't think the Supreme Court having commissioners make these factual findings is likely in our future. But what I will say is that the Supreme Court does have the advantage of having certiorari jurisdiction, and it can wait to take a case until it feels as though the record has been adequately developed.
I note in the Jarkissi case, Elon Werman, someone I disagree with on most of this stuff, filed a brief on behalf of neither side, saying that the issue in Jarkissi is the administrative law judges, and his theory about the unitary executive is that it applies to department heads. And I'll shout out Gary Lawson here as well, and Steve Calabresi on this point. The principal officer was a neologism. There was no principal officer in English history. There was principal secretaries. So I just want to give credit where credit's due. Many originalists do this work, and then I just want to name Elon Werman as someone who's didn't take the unitary executive side in the case out of a principled historical commitment.
Yes, ma'am.
Good morning, Audrey Lynn from Georgia. I want to say I've been fascinated today by the discussion of the need for a methodological consistency, the challenges of understanding the reliability of resources, sometimes the lack of resources, as well as where you start, where you end research. In my relatively short career, I've had the somewhat unique opportunity to work as a law librarian, an appellate law clerk, and now currently as a practitioner of a small firm. And one of the things that strikes me is the stark differences of informational resources and informational awareness in those three contexts. And so what I'm wondering is if, in light of the call for more originalist analysis that we see coming from the U.S. Supreme Court, is there correspondingly a call for greater collaboration between legal academia and courts and perhaps the continuing legal education experts to talk about and have a vigorous discussion concerning what kinds of resources need to be available to practitioners, to courts, in order to do this kind of analysis, as well as to educate lawyers and judges about appropriate research methodologies and reliable resources.
Well, I'm glad you made that point, because I think librarians in particular can be extremely helpful in this area. I mean, we in our circuit and district court have a tremendous librarian, and we can call up and say, help us find these sources. And I remember as a law clerk at the Supreme Court, we had the Library of Congress at our disposal, and I remember working on one project where we did end up doing our own historical research, and we called the Library of Congress, and they sent us some really helpful and interesting material. So I think drawing on librarians is something that could be very helpful.
There's experience with the courts trying to improve their institutional capacity in dealing with various kinds of technical and specialized questions, including, for example, economics and science. And so somebody who was interested in that for originalism, I think, could look to those models, what courts have done in the last 50 years, to increase their sophistication about other kinds of specialized inquiries.
Just very quickly, I just want, there are a couple of resources for those who want to get into this material about where to find materials. And so in addition to librarians, I think it's Steve Sachs and Will Bode wrote an article about, I can't remember which article it is, but if you search for mags, they cite a series of resources. And so there is a scholar, Gregory Maggs, M-A-G-G-S, never met him, but he has well documented the different resources, or you can
One
look
of
for
my co-clerks. She's a wonderful professor.
He's
Didn't
on the
even
Court
know.
of
That's
Appeals for
great.
the Armed Forces
Yeah.
now.
Great.
Yes.
Richard Samp, New Civil Liberties Alliance. I oftentimes get discouraged by whether we're ever going to arrive at any kind of consensus on certain issues about what history says, let alone how that applies to particular cases. Certainly that bothers me in the Second Amendment area. I have a question, I guess, perhaps for Judge Moss or anybody else. One issue that seems to be continuing to be contentious is whether a sitting president can ever be indicted. I know you have been involved very long in that issue. I'm wondering if your feeling is that over the years, have we arrived at any better consensus on that issue, or are the issues still the same when you were first involved 25 years ago in that?
So I'm not, I've not gone back there and had reason to go back and study that question again. But no one has brought to my attention new historical sources on it, but I have not gone back to look at it again. So there always are new sources. So if someone looked into it, I wouldn't be surprised if there was something else out there.
Penultimate question.
Roger Abbott at Malton Stockbridge. I have one question regarding how these court cases filter up. There seem to be a lot more originalists on the courts of appeal than at the district courts, and as a practical matter, what happens if an issue doesn't get raised before the district court because maybe you don't have an originalist judge, or maybe you just don't have the resources to raise an issue that it's unlikely. And so I think that's a real issue that you see, litigations that simply aren't raised, and I don't know if there's sometimes a way that judges on appeal can sort of slide them in, but that seems like a practical problem.
Anybody?
Yeah, I mean, what I'll say is I think that's an issue that comes up not just in this context, but in other contexts where issues become more refined as they go up through the appellate process, and There is more attention, additional briefing, amicus briefs as they come up through the process. And appellate judges have to make sometimes tough decisions about whether an issue has been preserved or not. And there's a continuum, because there are variations on an argument that was raised, but it may be raised a lot better on appeal than it was raised at the district court. But if it was raised, I don't think there's a prohibition on doing a better job of it in the Court of Appeals.
Last question.
One thought that occurred to me, Heather Hacker from Austin, Texas, one thought that occurred to me when looking at Judge Oldham's example of the very truncated docket that the court was working with in deciding a very complicated constitutional case is the practical problem. A lot of these very important cases coming up to the court in the first time in a very expedited posture, so in like a stay posture. Do you think that a potential solution to that problem, aside from perhaps practitioners being more judicious about asking for extraordinary relief like that, do you think that a potential solution to help the court is to allow more amicus briefs to be filed at the district court level in order to sort of front load that docket experience by the time it gets up to the appellate court and then the U.S. Supreme Court?
Yeah, I certainly think that's true. And you hit on a really important point that we haven't discussed yet today, so I'm glad we can close on it, which is that a lot of these cases do happen very quickly. It's never been obvious to me. I've read a lot about the emergency dockets and how they work, and obviously we see a lot of it in the Court of Appeals. And it's never been obvious to me what is exactly to be done about it, because when in any given case, the equities are such that it truly is an emergency. And so what are you supposed to do? It's not like we asked for the emergency. It just ends up there, and then it has to be dealt with. One form of solace that I have always taken in all of this, Justice Jackson famously said about the Supreme Court that they're not final because they're infallible. They're only final they're only infallible insofar as they're final. Well, we're neither, right? So we're neither final nor infallible. So I take some solace in the fact that we try to do the best we can, and thank God there's someone else behind us to check.
I've been asked to make two brief announcements before we break. The first is there will be a book signing for The Soul of Civility, Timeless Principles to Heal Society and Ourselves by Alexandra Hudson. That will be on the mezzanine level right after we break. The second is I've been asked to encourage all of the audience to socialize among yourselves and engage with the panel, but to please do so outside this room so that our logistics people can set up the room for the next panel. Please join me in thanking a great panelist for a wonderful presentation.